Okay. All right. Well, it is Monday, April the 13th, and welcome to week 2 of Constitutional Law. I'm Professor Richard Wright. Good to see um, you guys back again this week. And I'm going to share a few things with you. First of all, I'm going to make sure that you get well, I'll get to it in a minute. So what I'm going to do is I'm going to go ahead and I'm just going to share my screen. Okay. As you already are familiar with this information, so I'm going to skip all the way down here to week 2. You're going to be um, briefing a case, which reminds me I need to send you a instruction sheet to help you. I have that, and I'll send that at the end of this lecture today. But when you brief a case, include the facts from the case, and you'll see all of the settings that I'm going to send you. Make sure you have your citations and references. Then we got your first week of your Fourth Amendment project. Now, I want to say this to you that so you'll know up front. Week 2 is topic selection. Select a topic related to the Fourth Amendment. Explain why that topic was chosen, and then meet the satisfied requirements. And so we're going to make sure that we go over that in just a few minutes. I want to bring your attention though to week number 5. Week number 5, Fourth Amendment project, is going to be changed from an interview. It's going to end up being a research. So you're not going to have to worry about interviewing anybody about the Fourth Amendment. So we're not going to be doing that. I'm working on an alternate assignment as we speak now, and that assignment should be added by the end of the week. So be aware of that. So don't worry about this Fourth Amendment project. I'm working on that now. I have an idea about what I'm going to give you, and then we'll go from there. Okay, everything else will stay the same, except that when you get to the scoring rubric for week 6, um, this um, point about um, include the interview is not going to be part of your grade. I'm going to actually take that out, and I'm going to spread the points across evenly. Otherwise, it's still going to be 100 points. So be aware that the Fourth Amendment project interview for Module 5 will not go on as scheduled because of the fact that it's impossible for students to do this with the um, pandemic uh, coded COVID-19 that we're dealing with now. Okay, so don't even worry about that. I got you already covered on that. So tonight's lecture will last about an hour or less. And again, you'll have lectures week 3, 4, 5, and 6 also. This is the recording of last week's lecture, which you all should already have a copy yourselves. Okay, so let's go and look at our week 2 announcement. In week 2, we're going to deal with equal protection under the law. And I sent you the PowerPoint for chapter 4. Make sure that you look at Appendix E of the textbook as well and complete the activities, equal protection under the law, and briefing a case. Again, I'm going to provide you with some information to help you with that. So after the lecture, I will be emailing to each of you some instructions to help you with briefing a case. Also, the discussion assignment, is it really equal? And then prisoner equality. Each of those initial posts are due on Tuesday night. And then your reply posts are due Saturday night. Finally, be sure to complete the written assignment, briefing a case, and the Fourth Amendment project. Okay, briefing a case is your written assignment, and then your Fourth Amendment project. We're going to talk a little bit more about that. And then you already know about this: start strong, continue to be strong, and you know about my motto: adversity is a springboard to success. All right, there's your welcome announcement. It's still up there as well. So let's take a look at the course calendar. This is where we are right here. So here's your reading assignment that I just gave you a few minutes ago. This is your initial post and reply initial post for the two that are due tomorrow night. Your reply posts are due the 18th. And then your two written assignments along with the key word is due on Sunday night, 11:59 p.m. Central Standard Time. Okay, so let's go take a look. And again, I remind you, as I will every week, that the course ends absolutely on the 17th. That's your final class. That's the final day. Okay, nothing after that. All right, so now let's go and let's look at module 2. Let's see what the assignments are. So the course project is pretty straightforward. So it says, look up the Fourth Amendment in your text, look at some cases and secondary sources, and you could find that in the library. And after you've reviewed this amendment and the laws surrounding it, pick an area within the Fourth Amendment that you'd like to research further. Write a one-page, double-space paper indicating what area you've chosen and why you chose the area. Okay? Very, very straightforward. Here is the reminder for 100 points. That's all you have to do. I just showed you the rubric for your 100 possible points. And again, just to take you back, here it is. No, not briefing a case. This is your, here we go. Select a topic. You'll get half your points for selecting the topic. Explain why, and then satisfy the one-page minimum requirement with APA citations and references. That's it. Pretty easy, pretty straightforward. And of course, that assignment is going to be due Sunday. Okay, so any questions about this discussion, about not the discussion, about the start of the course project? If there are any, uh, you can put them in the chat box. Okay, and if I see no questions asked or someone says none yet, then I'll keep on moving, understanding that you got it clear. Okay, so it's pretty straightforward. It's not very complicated. Pick the topic, explain why you picked the topic, and then, go ahead and uh, do your research that you're going to do. All right, now that's the Fourth Amendment course project topic selection. Then you have how to brief a case. Now, you're going to brief this case, Terry versus Ohio. Follow instructions for briefing a case given in the briefing a case page. Now, that's going to be one place you can find it. The other place is I'm going to send you a email after class is over today, explaining to you how to brief a case. And it was actually I used it, it was from a law school article that I was familiar with. So the case is Terry versus Ohio. You should be familiar with that at the end of briefing it, because you have to look at it first. All right. And again, it's due Sunday. And then again, how to brief a case is also provided in the rubric. Including the facts from the case, includes procedure, includes the issues from the case, includes holding from the case. By the way, speaking of this, don't go on and copy a case brief that you'll find. I don't want you to do that. I want you to do it from scratch yourself, including the holding and the reasoning from the case. We're going to talk about that a little bit more in detail in just a few minutes for a total of 80 points. All right. Make sure you have a cover page. Right. At this point, um, you can hold your questions about briefing a case until we get actually into the lecture itself. Right now, I'm just going over the assignments. And then you have your two discussion posts. Is it really equal? What is really equal? The Equal Protection Clause. And it says that everyone has equal protection under the law. And this is the 14th Amendment, basically. Um, what are some instances where people are treated unequally? Is this fair? And this should be included in your discussion post initially. Okay. Of course, you know that's due tomorrow night. And then is prisoner equality. Equal protection also comes up in prisoner rights cases, what we call 1981 cases, which is a section of the United States Code. And then it says, do you think inmates should be allowed to file as many petitions as they please? Of course, there's some limitations. Uh, and then how to limit on the petitions and so forth and so on, and why. What is the reason why limiting the petitions? I will be sharing some information myself in my response to you based on my legal background and experience in terms of representing individuals who are prisoners. And then your live classroom lecture, the key phrase that I will give you that will be due on Sunday. All right, let's close this down. So let's go back. Okay, let me see what that question was that Junior raised. For the first written assignment, what do you mean by one area? What do you mean? A section from the Fourth Amendment. I was a bit confused about wording. One area of the Fourth Amendment. No, what that means is the Fourth Amendment covers various things, and you're going to discover what some of those things are in this lecture in just a few minutes. So the Fourth Amendment itself, going back to it, you'll see what I'm talking about. Let's go back to the course home. Okay. So the assignment that you're asking about, now this is about the brief. Is this what you're talking about? You're talking about in the course project? Is that what you're talking about, Junior? The course project and not the actual briefing of a case. You're talking about the course project, right? Is that what you're asking about? Are you asking about the course project? I'm assuming that from your question you are. No, it says select a topic related to the Fourth Amendment. Explain why that topic was chosen. And there are various topics that fall under the Fourth Amendment. And we're going to talk about some of those in just a few minutes. Okay. A minute here. Let's go back to the classroom. I went too far. There we go. Okay, module 2. Okay, now, if you, and when you read the chapter too, also, it will tell you the answer to your question as well. So I'm going to talk about equal protection under the law, and I'm going to talk about briefing a case. Those are the two things I'm going to talk about. But right now, I'm going to answer your question you should be aware of. Now, the 14th Amendment, this is what it says. I don't mean take a section out of the 14th Amendment statement. I mean that there are various topics that fall under the 14th Amendment. All right. And what that means, for example, there are issues under the 14th Amendment, such as discrimination, jury selection, racism, um, discrimination in criminal justice. So, um, so a section from the first 14th Amendment, Fourth Amendment, there are Fourth Amendment issues such as jury selection, such as individuals believing that they were discriminated against on the basis of race, maybe even religion, or maybe even sex or national origin. Generally, these are all things that fall under it. So the 14th Amendment, let me move this out of the way for now, involves the statement that all persons born or naturalized in the United States and subject to the jurisdiction are citizens of the United States and the state wherein they reside. No state shall make or enforce any law that shall abridge the privileges and immunities of the citizens of the United States, nor shall any state deprive any person of their liberty, property without due process of law, nor deny any person within its jurisdiction equal protection of the law. And what this is really saying, you should be aware of why the 14th Amendment came about. First of all, the 14th Amendment was an amendment that applied the Bill of Rights, the first 10 amendments to the Constitution, to the states. Before the 14th Amendment, those amendments 1 through 10, and in this class that we talk about in terms of criminal, I think we already discussed that 4, 5, 6, and 8 apply to criminal law. Well, with the change of the 14th Amendment, what has happened is that the 14th Amendment says, and that's why it says in there several places, no state, and it mentions the state. And the reason why it had to do that is because the original amendments that were written did not apply to state law. They applied only to federal law. And you're going to discuss various theories that deal with equal protection of the law under the 14th Amendment. Under the 14th Amendment. So that's what equal protection, it means just what it says. Is people should be treated the same regardless whether they're wealthy, whether they're not wealthy, whether they're African American, whether they're Caucasian, whether they're um, gay, or whether they're straight, or whatever their religious beliefs. That's what it means. So two of the topics that are included here are jury selection in cases. For example, it's quite clear that we know as lawyers we have what we call peremptory challenges. That is that we can shape a jury by denying someone the opportunity to sit on a jury for any reason that we deem, and we don't have to disclose it. However, if it becomes clear that the reason that you're using that peremptory challenge, which you only have so many, then you can't use them to discriminate against an individual during trial. So jury selection is one way that we deal with equal protection under the law and how it affects our system. And it says here that the peremptory challenges can be used for any reason that I just said. We don't have to give a reason. However, though, it became clear in 1986 in Batson versus Kentucky that we could not use these peremptory challenges to remove someone solely based on their race. So how do we come to that conclusion? Well, it's quite easily that if your challenges are to remove an individual, and that applies to the prosecutor as well as defense attorney, but removing a person because you feel like that person will not be sympathetic to you, but you're doing it on the basis of their race. Now, the pattern that comes out by selecting a jury is how that is able to be determined. So if you, as an attorney, like I did as a defense attorney, believe that the other side is removing but minority jurors because my client is a minority, then in that case, then I can file what we call a Batson motion and say that it is quite clear from the way that this prosecutor is trying to shape the jury is to remove African Americans or other minorities that would possibly be sympathetic, possibly, you hear me, sympathetic towards my client, the defendant. All right. Now, here's what happened in this case. If you go ahead and read it, you'll see what I'm talking about, the case itself. And I'm going to just read the language that it says here. It says the same equal protection principles are applied to determine whether there's discrimination in selecting the jury panel. The state's use, that is the prosecution's use of peremptory challenges to strike down jurors, uh, and although a prosecutor is entitled to exercise those challenges for any reason, as long as it is clear that it is not to deny that person the opportunity to be a juror because of their race. So the equal protection clause, and it's an interesting thing. The term equal protection means what it says. It is not it's a legal term, but it's really on its face given the definition in the name. But it forbade the prosecution to challenge jurors based on their race or on the assumption that the black jurors would be not impartial when it comes to the case against a minority defendant. And now you should be aware that there's some argument though with Batson that says it's not been extended universally to age, gender, or religion. However, there are some cases that are coming down at this particular time. So even with trying to do a Batson um, motion at this particular time, that we are doing it on the basis of the race of the individual. With the way that the law has changed, with the civil rights laws, with the equal protection, not equal protection, but with the sex equality laws and the gender laws, there will be cases that will be able to apply Batson versus Kentucky. For example, I can foresee a case where an individual is gay and anybody who on the jury may even appear from the other side to be gay, that the prosecution, and interestingly enough, that the jury selection and dealing with this issue seems to be the prosecution because they have the burden of proving beyond a reasonable doubt that a person committed the crime. But I can foresee that taking place because remember from the time 86 that the Civil Rights Act has been extended now to deal with sex, and there's some arguments that it deals with age as well. So the gender of an individual. So you guys see where I'm going with this? Everybody got it now? Yeah. So it's quite clear, like I said again, it somebody said, well, what is equal protection? Okay, here's what equal protection is supposed to be. Have you guys seen the scales of justice before? Have you ever seen the scales of justice? Okay. Now, if you notice the scales of justice, give me a minute. Give me a minute. Give me a minute. Some of you may not have ever seen it, but I'm gonna just do a simple Google search. and I'm going to show you something. Scales of justice image. So first I'm going to do the meaning, because this is what I want you to understand. So what it says here is, yeah, it's kind of interesting. Here it is right here. Represents the balance of the individual against the needs of society and a fair balance between the interests of one individual and those of another. And, so it explains. So it basically says that things should be balanced. And so what does it symbolize? Fairness. That's it. That's it in a nutshell. And there are plenty of examples here that you can find. Each side of a case will be considered in a court case. Additionally, the scales underscore the decision will be made by weighing the evidence in a fair and impartial manner. Now, the sword symbolizes the lady's authority. You see the authority. See, somebody who has carried the swords, they can stick you with that sword. And unfortunately, I have said this before, that if you look at the scales of justice, let's say, for example, the reason why we say that the scales of justice are blind, and I've used this before, and this is what I say it all. Justice is impartial and objective. So the Greek statue, which is what that woman represents, is wearing a blindfold so as not to treat people differently, whether they're rich or poor. That was what I had said to you earlier. All right. So here's the symbol. Here's really what it looks like up close. And there it is. Let's blow it up. So you see, she's holding the scales of justice. Sometimes you see the sword down, but the scales are held in balance so that each side is equal. And that's what the scales of justice. In this picture, she's not blind, but there are some instances that you will see that she is blinded. So has everybody got the point that I was trying to make? You see what I'm saying? Okay. It's not, as somebody said, it's not really that deep. It's just common sense. That's all it really amounts to. So this is one example of where equal protection of the law applies. And so now let's look at this next section here. It says discrimination exists at every level of the criminal justice system. It starts with racial profiling. People are treated on the basis of presuming that because they are a certain ethnic group. I had mentioned before, and I don't know if I mentioned in this class, but I mentioned in probably in some of the other classes that you had with me, that I attend every year the Illinois Association Chiefs of Police seminar. And also, that I was previously a law enforcement officer for about 4 years. Well, everybody with the term racial profiling understand that that means that it's presumed that all blacks commit crimes. Okay, all all Caucasians are racist in terms of applying these. This is racial profiling. And unfortunately, though, with the racial profiling, when it comes to minorities, it is presumed, and as an African American, I'll use my own self as an example. It's presumed by some law enforcement officers that African American males are violent people. I was told this in that seminar by a Caucasian police officer, that he was afraid of African American males, and therefore when he approaches African American males, he presumes that they're going to first be a certain way. And that's problematic. That's problematic. And so a presumption or assumption or conclusion without any basis. Everybody is an individual and should be approached from that fashion. I don't believe that it is um, equally distributed when it comes to even to the jails, because the percentage of African Americans is very, 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 very high. So if you have a conclusion or assumption that because a person is a certain race, that they're going to respond in a certain way, that's what we mean by racial profiling. And I remember being stopped driving in a certain neighborhood, and the police officer asked me why was I in the neighborhood. And I said, well, I was visiting someone. Who do you know in this area? And what the officer was really saying to me was, you're out of place. That's sad, people. That's sad. And unfortunately, it takes place at every level of criminal justice: probation, parole, prisons, jails, in the courtrooms, law enforcement, even with the attorneys practicing law. Give you an idea. I remember representing a guy in a suburban community far west in Chicago in the 80s. And I was in the courtroom, and he had a DUI, and he was Caucasian, and we both were dressed in suits. We both carried briefcases. And so when it came time for the case to be called and we stepped up, I began speaking, and the judge stopped me, not once, not twice, but 3 times, and said, uh, let your attorney speak for you. He presumed that because my client was white and was dressed and looked like what he considered as an attorney, then he actually thought that I was a defendant. Well, he found out from my client that it was the other way around, and he was embarrassed. And that's what happens, unfortunately, in situation. But the sad part about it, people, is that it extends to how people are sentenced. It extends to how people are charged and those kinds of things. And so the incarceration numbers, as they talk about, uh, give a light to some of the things. If you look at the Bureau of Justice Statistics, this is actually old, but the annual review of local jails, it stated that 44% of the inmates, blacks 38%, Hispanic 16%, and then they have remained pretty stable since 2005. So there's something wrong there. Uh, and I can tell you that wrongful convictions that I have looked at have been disproportionately distributed among African American and Hispanics. And so I'm saying that is that the numbers speak for themselves. So what I'm doing here is I'm bringing this to your attention, because this is an example of what we're talking about, how the equal protection clause really isn't equal. Remember, with that scales of justice, the person or persons who must make the decision about the fate of an individual who is on trial in a criminal case would be better if they were blindfolded, then and then you could take the voice of the person, and then you phase it so that the person wouldn't know whether that person was a certain ethnic group or race. Then we might have a difference. That's what that whole thing is all about. Is everybody with me? Everybody with me? And it's if you understand, who in this room does not want to be treated fair? Raise your hand or tell me. Say, I don't want to be treated fair. I don't think anybody's gonna raise their hand. Because you don't. You're just not gonna. That's human nature, people. Everybody wants to be judged fair. That's why we attempt to pick a jury that is Junior says fair and square. Okay. Fair and impartial. Fair and impartial. Notice it says fair. And when I was in law school, our professors used to tell us that the term justice, don't even use it in law school. And the reason why they didn't is because we would recognize that you would be painting the whole system with a broad brush. And the professors would laugh about it, but we also need to fix it. How do we fix it? By having people to go in these positions from law enforcement all the way through to being attorneys and judges and prosecutors and defense attorneys and all aspects, parole officers, probation officers, and the whole 9 yards, where we apply equal treatment and fair treatment to individuals that we are to work with. It's almost like if the golden rule was applied: do unto others as you'd have them do unto you, or treat somebody the way you want to be treated, then we might have some parity when it comes to dealing with not just criminal justice, but in life, period. But since we're talking about criminal justice, it certainly fits. So in a survey, it says of 40 urban counties across the United States, and this was as of 1998, 62% of the juvenile defendants were Black. 62%. 62%. Okay, that's 50 plus 12. Okay, while Caucasians, 20%, 16% were Hispanic, and almost 2% were other races. But look at what we're talking about here, and that shows you what we're talking about utilizing the statistics. So we try to tell people biblically, when I talk about my job as pastor, let a man examine himself. And my grandma used to say, every tub got to stand on its own bottom. In other words, everybody should be judged by their actions as individuals, not based on their race, their religion, their sex, or national origin. Every person who is of a certain race is not going to operate the same way. Okay? Let's get that in our heads, hearts, mind, soul, and spirit, and we'll be on our way. All right. So according to the Bureau of Justice Statistics, a survey done in many local police departments across the country, look what it said it found. And you can, by the way, you could open these up, take a look at them, and you can see more in detail the information and data. And you can find that, and you can even update it and apply it. But the point of the matter is, it said quite clearly here that across the country, it was found that only 1 in 4 officers were members of a racial or ethnic minority. Now that has changed. That has changed. Chicago, for example, I remember living in Chicago, even as a teenager, when seeing a white cop was the norm. Seeing a Black cop was unusual. And now many jurisdictions now, and listen to me good. I'm saying this not to say that a person of another race can't be fair and impartial, can't do their job in law enforcement. I'm not saying that at all. So I'm not saying that black officers should have, uh, excuse me, black defendants or Caucasians should handle that. No, I'm never going to say that. What I am going to say is that it is quite clear that the individuals who are in that community are looking to see people who are like them. That's the kind of thing we're talking about. Somebody, one of my friends, he said to me one time, he said, "Man, I'm a white boy from the suburbs." He says, "All I see is white police officers. But when I come into the area in the city and I see black police officers, I feel like, uh-oh." I said, "See, so the point of the matter is that why are we doing this? Why is your mind like this? Why is it operating like that? It needs to be fixed, and individuals need to be taught." That's why we deal with, by the way, diversity and inclusion as an important factor in our classes. When we talked about that, remember all the weeks that we talked about the transferable skills. Everybody remember us having a discussion about diversity and inclusion? Everybody remember that? And we want to carry that over into how we operate as individuals. And so anyway, just a mere statement. I had a person one time tell me, when I said black power, they thought I was being radical. I says, no, I wasn't being radical. I says, if you turn around and say Irish power, that's a popular term in Chicago, if you know anything about Chicago. And you know that St. Patrick's Day, everybody is supposed to be Irish, regardless of your race, religion, or national origin. But the point of the matter is that it's just pride in who you are. I think people should take pride in who they are. I think um, I have my Hispanic friends. I tell them, I say, don't deny your culture. Your culture is important to knowing who you are. Excuse me, let me move my seat up here. Move your culture, so you can understand who you are. It's not a separation statement. It's like my last name is Wright. I take pride in that name. Well, I have so much fun with it because it's the right way or it's the highway. That's what I tell my kids at home. Of course, they all got the same last name too. So, but you know what I'm saying there from that particular point. But I'm saying all of this to say that good people, we need to apply some common sense when it comes to dealing with individuals in the criminal justice system in all areas. And so these numbers that we're talking about should be, and somebody said, well, the reason why those numbers are like that is because those people are bad people. So, uh-oh, those people are bad people. What about, let's get to the core of it. Let's get to the heart of the issue involved here. So anyway, the point of the matter is, it says that 1 in 4 officers were members of a racial ethnic minority. And now that's changed because of, as I said, the importance of recognizing the need for diversity and inclusion. And then in data collected from the federal law enforcement agencies, only 1/3 of federal officers were members of racial and ethnic minority in 2004. 17.7% were Hispanic or Latino. And look at that, 11% were Black or African American. Okay. And in 2002, the racial or ethnic minority officer comprised 32% of federal officers. I don't know if I've ever shared this with you, that when I was in high school, I had decided that I wanted to go to the work for the FBI. And the way I was going to get my education, because I had said I wanted to be a lawyer, is that I discovered that you could go through the FBI and then you could go to school and work for the FBI, and then you could become a lawyer. And it was back in those days, it was lawyers and accountants. Now it's a whole lot of other areas as well. But back in the 60s, that was a pathway that I decided that I would utilize to try to become a lawyer. So I applied to the FBI. I put my application in. The FBI agents actually came to the high school. They went to my neighborhood. They talked to people about me. But, and then there was another friend of mine. Uh, he was Caucasian, and we both said, "Hey, we'll see each other in the FBI." And we decided that that was our thing that was going to happen. Well, I didn't get accepted. I didn't get into the FBI, and I went on with my life. But then years later, I got a letter of apology from the FBI saying that when they went back and dug this, not just me, but others, my application, they discovered that the reason why that I was rejected was because I was African American or black. The head of the FBI at that time was J. Edgar Hoover, and he was summarily dismissing minorities, particularly African Americans and women. So he was racist and sexist. And so what I'm saying to you is that even coming up to 2000 and 2004, and they're talking about a statistic, it's showing that there's some changes, but they're not as many. And so it is being fixed, it's being worked on, but we still got a lot more work ahead of us. So according to the U.S. Department of Justice, the racial disparity for judges across the nation was extreme. I can tell you that when I came up, I hardly saw a black judge. And when I saw a black judge, I was like, wow. Well, now, particularly depending on what areas you go to, you might find more. I'll give you an example. I'm from Cook County, Chicago, Illinois. Cook County has a tremendous number of African American judges. And in fact, the judge that is the presiding judge, who I know pretty well, is Tim Evans. And Tim Evans is the chief judge. And then there are other presiding judges within the divisions that have been appointed that were African American. One of them is a young man by the name of Leroy Martin. He was one of my first lawyers that worked for me in my law firm. His dad was chief of police in the 80s and 90s with Mayor Harold Washington. Anyway, there were many that came about. However, now I live in Kendall County, and there's quite a few African Americans in Kendall County, and there are other professionals that are in Kendall County, and I'm involved in somewhat in the political scene out here in the area. But I've learned that there are no African American judges on the bench in Kendall County. In Will County, I know there's one for sure because I helped get him elected when I was living in Will County, but I think it's only one. I remember when I was a practicing attorney, there was one that was there for many, many, many years. Um, I remember even when I represented individuals in bankruptcy court, there was one African American judge. His name was Ed Tolles. And then David Corr came later, and he went to the federal district court later. And and that was it. But guess what? Many of the individuals who came before the judges were individuals who were filing bankruptcy were African American. So there was a disparity across the nation. So it says in 2004 in Wisconsin, there were 240 circuit judges, 229 of which were white, and only 6 of which were African American. And I'm willing to bet you that of those 6, they probably were from Milwaukee. And 3 were Hispanic or Latino. So the point of the matter is that there's some disparity even from the individuals who are the triers of fact. So we can continue to look at this, and it concludes here by saying it's important to examine the demographic makeup of the prisoners, law enforcers, and the judiciary, because it explains why we have some of the problems we have in our world. So that's pretty much it for dealing with the equal protection under the law. Any questions? None at this time? Okay. Anybody else? None? Okay. Okay. You know, it's very interesting. I was talking to a young man who's in my Introduction to Corrections class, which many of you were in when it was an 11-week class, and he was telling me that he heard me use the term firm, fair, and consistent. And I told him that I actually got that from a student who was a correction officer, and she was African American, and she was saying how, as a corrections officer, that in order for them to be successful and do their job really well, they had to apply that principle of firm, fair, and consistent, which means there was no arbitrarily capricious or determination. And so I would say that we need to apply that across the board in criminal justice: firm, fair, and consistent. And, individuals need to be uh, sentenced for crimes that uh, they commit in a fair manner as well. Okay, so there's some work we got to do. Um, this is a video that'll give you details regarding the investigative position in the public defender office. Um, Most time, let me see if this link works. I'm just going to check to see if it works, because some of them you click on, they don't work, like this one. Yep, they don't work. And that's something that I got to bring to PSC's attention so that we can see that information. So you got enough information on equal protection under the law to be able to pick an area that you want to be able to utilize. So now let's talk about briefing the case. Now, I am going to send you some material, but this is kind of the same kind of thing, but it's going to be more in detailed. So the reason, let's see, somebody put something in here, and I think I know what they said, but let's go back to the chat. Let's go down here. Okay. Sometimes if you right click and open in a new window, the link works. That may be true. I've seen that happen, but let's see if that happens here. Let's try it and see. You might have a point. Let's see. Open link in a new window. Let's see what happens. Thank you. There it is right there. Okay. And then they got cookies and stuff like that. No, don't get your milk. Okay. It's not the same thing. So, so yeah. So then you can go in and you can see the video. Good point. Thank you so much. But I don't know if that works for everything. Um, let's see, video management, open a new window. Let's see if that's going to happen. Okay. And this just tells you how to find how to operate the content and so forth and so on. So I guess you could do the same thing there. So, okay. Thank you so much. Who gave me that? Who gave me that? Katie. Thank you, Katie Ann. I figure Ann would give me the correct answer to anything. I'm married to one. Her name is Julia Ann, but she has no E like you. But that's a whole nother thing. And for 25 years, she has done that to me. She says, why don't you do this? And it seems to work. So I just crawl back and say, okay, dear, you're right. Okay, thank you so much. Thank you. Appreciate that. That's why I like my students. Trust me, I can learn something new just like anybody else. So anyway, here we are showing you how to brief a case. Look what it says in bold print. Do not copy and paste from another source. This should be in your own words. Just because you find, just because you're able to brief your case somewhere on the internet, you find it, does not mean you should use that brief. I already said that. Okay, because I run them through Grammarly. The entire purpose of briefing this case is art that helps you to understand. And it says the entire purpose of briefing a case is lost if you're merely copying someone else's work. We call that what? Plagiarism. And we've already discussed that before. So we're not going to be doing that. So what we are going to do, and so this is kind of like a summary of your case title, which is Map versus Ohio, your case citation, which you already have that, and you should know what your citations stand for, just to share with you. See, this says 384 US 436 1966. It means that you could find Miranda versus Arizona in the 384th volume of a publication called the United States Supreme Court. At page 436 is where it starts. And 1966 is the year that the case came down. That's how old Miranda is. All right. So what you're going to do in your facts, and it tells you in copy, in bold, summarize the facts. Do not copy and paste from another source. I already told you that. List what happened in the lower court. Just brief details. Issue. What is the question that the court is dealing with? And the issue questions in a way that can be answered by yes or no. That's how it's going to be written in your briefs. Holding. What did the court decide? Did the court answer the issue question, yes or no? And then brief elaboration, brief. And then your reasoning. This is the most important section where it explains what the court's reasoning behind the holding. And if the law is changing, explain that too. And then very important, concurring and dissenting opinions. Now, let me explain to you what a concurring decision is. A concurring opinion is when the court agrees with the decision of the court, but for different reasons than what the majority said. That's what it really means. Dissenting means they absolutely, totally disagree. And it means that, and they'll elaborate on reasons why that is. And so only include this section if you believe the concurring or dissenting opinion is important. Yours truly believes that is important in all my briefs. Hello, somebody. So I'm telling you, um, make sure that you do that. Now, let me give you an example of what I'm talking about. There is a famous case called Plessy versus Ferguson, and this is a civil rights case. And I forget the year of Plessy versus Ferguson, but Plessy versus Ferguson was a case that said separate but equal was good law. Okay. Now, in the Plessy versus Ferguson case, it is stated quite clear. If you ever read the case, it's an old case, and I'm pulling something up. Okay, it says that landmark 1896 Supreme Court case that upheld the constitutionality of racial segregation, or saying that separate but equal doctrine. And the case stemmed from an 1892 incident in which an African American train passenger by the name of Homer Plessy refused to sit in a car for blacks. In other words, feeling that that they should be able to sit in cars with anybody else. And so Plessy versus Ferguson set the law. Now, it was finally, if you ever read Plessy versus Ferguson, you will see the dissenting opinions that state the reason why this needs to be changed. And it gives some good reasons. It was not until, good people, 1950, let's see, 4, I believe it was. I believe it was 54, when Brown versus the Board of Education. I think it was 54, May. It was actually May 17th, 1954. So it was until 1954 finally where a unanimous decision was entered overturning Plessy versus Ferguson. Think about it, all those years, it still went on. And this was before the Civil Rights Act of 64 and 65 and so forth, and the various civil rights statutes came about. So what I'm saying to you is that in and by the way, when the arguments were made about Brown versus the Board of Education, and a famous individual who became a Supreme Court justice later in life, his name was Thurgood Marshall, first African American justice of the United States Supreme Court, argued this Brown versus Board of Education case, and they utilized some of the language from the dissent of Plessy versus Ferguson as to why we are being set back. And so now we bring that full term forward. Now we're talking about diversity and inclusion. There was no such term to talk about before that. So that's why I'm saying that dissenting opinions do shed light on changes in the law. Okay, and that's it for today. Any questions? Any questions? All right. So now let me give you a key phrase. Anybody have any ideas what the key phrase is for this week? Oh, I already know what I'm going to do. Type it in the chat box. Any ideas? Nobody want to take a shot at it? Take a shot at it. Fourth Amendment. You're getting there. Fairness. Nope. Michelle Larrabee. Schmuck. Schmuck. How do I pronounce it? Did I say it? Schmuck? How do you pronounce your last name? You know what? Hold it. Forget that. I'm gonna let her tell us. Michelle,
Yes.
how do you pronounce your last name?
Larrabee Schmunk.
Okay, not schmuck, right?
You were close.
Okay. I know you were laughing when I did that, so that's why I said, let me put you on so you can say
I
your.
hear it often.
Okay, yeah, because that's a comical term that comedians use. You're a schmuck. Okay, you've heard that before. Okay, so no, I'm not a schmuck. I'm a schmuck. Pronounce it completely. All right. But Michelle, you know what? I know your name. I know all of you guys from my class, and I appreciate you guys. So I'm going to close your mic off. So I'm going to tell you that Michelle got it. It is. Now, Katie, you were close. Michelle got it. Equal protection. That's it. That's the key phrase for today. You know, if you pay close attention and you begin to learn to listen to me, I give the clue throughout the whole lecture about it. You notice that the last one that we had was adversity as a springboard to success. I started out by explaining how important that was in terms of success and making sure that you understand. So you can, if you're really honing in on the topics that I'm discussing, then you got it. So yes, that is it. All right. So any questions, guys? Yeah. You know what? Okay, I'm gonna bust her out. Okay. What do you mean by that? I can hear you now. Say it. Katie Ann, what do you mean? Your mic's open. You can speak. Um, did I open it? Yeah, I opened it. She's not gonna say anything. Your mic might not work. Okay, but you're. Yeah, that's true. That's true. You know, older computer. Okay. All right. Do you have Windows on there? You don't have DOS on it, do you? You know what DOS is, right? You might know what DOS is. But I've had you. Oh, yeah, I know. I knew that already. That's why I'm messing with you. That's right. One of the things I like is I love my students that pay close attention. So that means that if you're ever anywhere in the world and somebody turns around and says adversity is a springboard to success, you'll ask them, "Did you know Professor Wright?" But because I've been saying that for years and years and years, and it actually had come to me from someone recently. I mean, very recently, that they said that someone once said, adversity is a springboard to success. I said, where'd you hear that at? They said, well, it's a professor at a college. I says, you know who that is? That was me. So, uh, oh, okay. Oh, okay. Thank you. So I appreciate that. So just send me my copyright money. That's all. I'm just kidding. Okay. So anyway, I'm gonna say good night to you guys. Again, it's been fun hanging out. Look for this email. And again, I do want to remind you that don't worry about Module Five's project. I'm working on that. Matter of fact, I'm going to be doing some work tonight and early tomorrow morning on getting that done. I got to run it through my dean. Uh, we got we just got a newly selected dean in the School of Justice Studies. She's a really, really, really cool person. I worked with her on diversity and inclusion. Her name is Rakisha Gilmore, and she is now our new dean for the School of Justice Studies, and she and I will be working on getting that done. Of course, some of you already know Jerry Lee, who is the department chair. And so, anyway, well, thank you so much, you guys. Yep. Good night. Stay healthy, and I'll see you next week. Um, with another edition of constitutional law. So again, keep your eyes open for this email that's going to come to you afterwards. All righty. Good night.